Under what circumstances are sanctions legal?
That's probably one of the most complicated academic questions, because as for the current moment, there is no international treaty providing for definition of sanctions. And that's why the problem is so enormous, because, for example, the resolution establishing my mandate, as well as relevant resolutions of the Human Rights Council and the UN General Assembly, are speaking about illegality of unilateral coercive measures. But to tell the truth, haven't seen any single case when a state says, yes, we are applying unilateral coercive measures. States usually say that they are applying sanctions or restrictive measures or security measures or anything else. And in the absence of definition, it's very complicated to see what we are talking about. That's why I will probably do an overview what types of activity which may influence behavior of other states or individuals is legal from the point of international law. And here, first of all, it's necessary to mention that the UN Charter expressly provides for the possibility of the UN Security Council to consider situations of the breach of peace, threat of peace, or an act of aggression, and to impose enforcement measures, both military and non-military. But in this case, there is a need to have a resolution of the UN Security Council adopted in accordance with the procedure of the UN Security Council. It's also possible sometimes for states to influence behavior of other states via legal activity. So let's call it unfriendly, but legal activity. States are absolutely free to trade or not to trade with another state, to sign some sort of cooperation agreements, or for example, mutual investment protection agreement, or not to sign that, prolong this agreement, or decide to stop these sort of relations. And usually this sort of activity is influencing the behavior of states which are also interested to cooperate quite a lot. However, if state, for example, decides to withdraw from the international treaty as a sort of demonstration of unsatisfaction by the behavior of the counterparty state, it's necessary to do that in accordance with the rules of the law of international treaties. War in advance, complete its obligations, and to withdraw. It's also possible, states may also impose countermeasures in response to the already existing violation of international law by another states, in accordance with the law of international responsibility. Usually we speak about situations when, for example, violation of an international obligation by one state directly affects rights of another state. But international law also knows situations when the level of violation is so enormous. For example, when we're speaking about situations of aggression, genocide, apartheid, for example, the situations of ethnic cleansing, so really scary situation, when the whole world community is considered to be affected and can violate certain international obligations in response, and it will be considered to be legal from the point of international law. However, it's necessary to take into account that in these situations, measures taken, first of all, shall be proportionate to the violation, and moreover, they can't violate peremptory norms of international law, especially humanitarian law or fundamental human rights. Unfortunately, when we speak about the unilateral sanctions today, quite a lot of measures are affecting fundamental human rights, including the right to life, or for example, the presumption of innocence. When people are listed for something what is not considered to be the crime under the criminal court of the state, or the state has no jurisdiction to do that. And another situation which also existed, the situation when a person, for example, is accused in committing international crimes. In these cases, we have International Criminal Court, which can consider the case. And moreover, as it has been established, for example, by the principles of Nuremberg Tribunal already in 1946, states have universal jurisdiction over the international crimes committed by the individual. it's also necessary to remember that if the interests of states, or if a state has a jurisdiction towards a specific crime, it's possible to use this mechanism. And I will cite here, for example, a number of people which have been listed as committing, for example, a cyber fraud or a fraud to the citizens of the United States, the foreigners who did it in the distant way with the use of IT means. Some of these people are listed, designated as by the United States, their assets are frozen. And as I saw from the material, the damage committed is pretty high. So we speak about several $1 million as a result of the being stolen as a result of the committed fraud. But in this case, there is a mechanism for to bring people responsible in accordance with the criminal law. And if the criminal case is started, if a person committed a crime, may be held responsible under the criminal procedure. And in this case, all procedural guarantees will be provided for the individual. So the process will be legal.
When are sanctions appropriate and in what form? Moreover, could you please explain what is the difference between the sanctions you are investigating and the boycott of apartheid South Africa or the BDS campaign against Israel?
Well, when we speak about the legal activity, which is called sanctions, I will start from the end of your question. When we speak about the measures which have been taken at certain point against South Africa, as well as some other countries, we spoke in that case about sanctions which have been adopted by the UN Security Council. In accordance with Articles 24, 25, as well as Chapter 7 of the UN Charter, the UN Security Council is entitled by the world community to serve as an organ having an exclusive right to qualify a situation as constituting breach of peace, threat of peace, or an act of aggression, and to decide what enforcement measures, non-military or military, shall be imposed over the specific state to stop this breach of peace, threat of peace, or an act of aggression. Therefore, measures which are taken by the UN Security Council are legal. And if we look at the history of functioning of the UN Security Council, period of 1990s has been called in the doctrine the decade of sanctions. So the Cold War was over, the UN Security Council was very active. It was possible to find the consensus between permanent members of the UN Security Council, and a number of sanctions regimes have been implemented. At the same time, even when no one can doubt legality of sanctions imposed by the UN Security Council, at early 2000, it started to be clear that the humanitarian effect of even these absolutely legal sanctions is enormous. There is a number of research and works done by humanitarian organizations, as well as a number of academic works, which assess the humanitarian consequences of sanctions of the UN Security Council, for example, as imposed against Iraq, against some other states. And it appeared that despite the fact that this activity by the UN Security Council was legal, humanitarian impact was enormous. And that's namely because of that, the UN Security Council started to review its policy towards application of sanctions. If you look today at the sanctions of the UN Security Council, they much more frequently are targeted. The lists of people which are targeted by the UN Security Council are much smaller in comparison with lists of people targeted by the United States, European Union, or any other states. Moreover, well, the process of providing the due process is not perfect still, but some steps are done, like, for example, through the establishment of ombudsperson or a focal point to guarantee the possibility to request for delisting. And the UN Security Council provide the possibility to take enforcement measures against states, not unlimitedly, or it doesn't provide now for the possibility to apply all measures necessary to do something as it did before. Quite often it provides for specific measures taken and provides a specific duration of its authorization, because initial resolutions of early 1990s have been unlimited. For example, the operation in Iraq in 2003, the coalition of states were referring to the resolutions of the UN Security Council of 1991, when they basically have been given to stop Iraq's aggression against Kuwait. And that definitely wasn't the case in 2003. So the UN Security Council is trying to control now humanitarian impact of its sanctions and demonstrate a very high progress in this area. Unfortunately, when we speak about unilateral sanctions, they have no ground under international law, beside the cases which I mentioned and upon which, for example, like countermeasures or unfriendly legal activity, which upon my opinion are not unilateral coercive measures and can be done by states legally. And the second problem is that unfortunately, there are nearly no mechanisms of humanitarian assessment of these measures taken. And that was exactly the reason why this mandate, the mandate of the Special Rapporteur on the negative impact of unilateral coercive measures, has been established in 2015.
Thank you very much for this interview, Professor Douhan. I wish you
It was a pleasure. Thanks a lot.
I wish you all best for your work